The courtroom in Los Angeles was packed to the brim. Legal experts, journalists, and intrigued onlookers filled every available seat. The air buzzed with hushed whispers and the rapid scratching of pens on notepads. It was supposed to be just another day, another routine hearing. But today, an unexpected presence commanded the room: Barron Trump. Judge Ronald Beckett, a man known for his sharp tongue and no-nonsense approach, settled into his chair. His gavel tapped methodically against the desk as he observed the young man standing before him. At just 18 years old, Barron Trump was a stark contrast to the seasoned litigators who normally graced Beckett-Montde courtroom. Dressed in a flawlessly tailored suit, he looked more like he was playing a role rather than belonging there. The judge sighed, adjusting his glasses with an air of amusement. "Mr. Trump," he began, his voice laced with dry skepticism. "I must say, this is a first for me, an 18-year-old expecting to argue a case. Now, I understand your last name opens doors, but my courtroom isn't one of them." Laughter rippled through the gallery, with smirks exchanged among the attorneys. But Barron didn't flinch. He stood poised, hands clasped in front of him, his expression unreadable. No fidgeting, no nervous glances, just unwavering confidence. Judge Beckett arched an eyebrow, intrigued. "Nothing to say? No speech prepared?" The judge prodded. "I expected at least a half-hearted attempt to justify why you belong here." More chuckles from the audience. Someone whispered, "He's out of his league." Then Barron spoke. His voice wasn't loud, but it carried a steadiness that silenced the room instantly. "I wasn't aware the purpose of this court was entertainment, Your Honor." The murmur of amusement died on impact. Eyebrows raised. The judge's smirk flickered ever so slightly. Beckett flipped open the case file before him, his amusement giving way to curiosity. "Well then," he mused, "let's hope you can back up that confidence with something more than just your last name." A subtle shift in the room followed. The assumption had been simple. Barron Trump would stumble through legal jargon, make a fool of himself, and serve as yet another example that privilege didn't equate to competence. But now there was doubt. "All right then," the judge said, waving a hand. "Let's hear it. Show me what you've got." What happened next, no one in that courtroom, not the attorneys, not the judge, not even those watching from home, was prepared for. Barron stepped forward with deliberate ease. He placed a meticulously organized set of documents on the podium and carefully flipped open a legal brief, the motions seamless, practiced. Judge Beckett watched with the same detached amusement, expecting hesitation, maybe a stammer or a misstep. But none came. "Your Honor," Barron began, adjusting the microphone, "before we proceed, I'd like to address several misinterpretations of legal precedent that have already been presented in this case." A pause. The quiet hum of whispers and the scratching of pens slowed. The opposing counsel has repeatedly cited Harper v. Sullivan to dismiss key testimony. However, that ruling was based on evidence obtained through unconstitutional means, circumstances that do not apply here. It is therefore irrelevant. A flicker of movement from the opposing counsel. A veteran litigator in his 50s. He shifted uncomfortably in his seat, flipping through his notes. Judge Beckett raised an eyebrow. "Is that so?" Barron nodded, flipping a page. "Yes, Your Honor. In fact, if we're discussing admissibility, Foster v. Crane would be the more appropriate precedent. That case directly addresses testimonial credibility under conditions of indirect coercion, which is far more relevant to our current argument." A low murmur rippled through the courtroom. The legal experts in the gallery exchanged glances. This wasn't just posturing. This wasn't just a kid throwing around legal jargon for effect. This was precision. Judge Beckett leaned forward slightly, his earlier amusement fading. The opposing attorney wasn't about to be bested by an 18-year-old, though. He stood, adjusting his tie. "Your Honor, with all due respect, we're not here for a law school debate. The argument remains that if you're dismissing precedent because it's inconvenient, Barron interjected smoothly, that speaks to the weakness of your case, not mine. Silence. The opposing attorney hesitated just for a fraction of a second, but it was enough. The balance in the room shifted. Judge Beckett turned his gaze toward the attorney. Would you like to respond to that? A long pause, then through clenched teeth, I'll address it in my argument, Your Honor. A retreat? Everyone in the room knew it. The attorneys, the journalists, the judge himself. And Barron? He merely adjusted his papers, waiting for the next move. Judge Beckett tapped his pen against the desk. Consider.